All right, this one's messy in the best courtroom drama way. 3 kids, a custody battle, and money that doesn't quite add up.
Mr. Cox on behalf of the plaintiff, Ms. Jernigan on behalf of the defendant. This is the defendant's motion for a temporary order. I have read both the motion and the response. Ms. Jernigan.
Thank you, Your Honor. Yes, we're requesting, obviously, some assistance in this case. We're requesting joint legal custody. The parties have 3 girls, Adeline, 16, Michaela, 13, and Lyra, age 7. Now, just recently, my client has been getting parenting time with the 2 minor children, anywhere from 4 to 5 days a week. The oldest child, Adeline, has been reluctant to spend the night at grandmother's house. I think there's a lot of, this is a high conflict, or I'd categorize this case as more of a high conflict situation. I think Adeline's just trying to keep the peace. So I'm requesting a 50-50 parenting time. My client lives 20 minutes away with her grandma. She's been providing all the transportation. I think we keep that in place. The plaintiff isn't really welcome, I guess, at the home of the grandmother. There's been a lot of verbal comments that are just not helpful in these types of situations. The plaintiff owns his own construction business. It's Roslyn Construction. He filed his complaint for divorce in February. We really tried to go through the financial pieces that we had, and my client has not really been allowed to access the joint accounts and the joint credit.
And there it is, the moment everything shifts. A subpoena pulls bank records showing significant deposits. In family law, that's a big deal. Why? Because courts don't just listen to what you say you earn, they look at what actually hits your account if those numbers don't match the story. Credibility starts cracking fast.
Credit cards. We pulled the data that we had. We just received a subpoena response from Lake Michigan yesterday on Roslyn Construction. There's significant deposits into the construction account. So the plaintiff's assertions that he doesn't have any money.
Wait a second, a Cadillac right in the middle of a financial dispute that's not illegal, but it is risky optics. Judges notice spending choices like this. So what do you think reasonable purchase? Or terrible timing?
To provide any type of child or spousal support it's just not substantiated under the circumstances. I would like to note, since we filed our motion, the court did delay another 30 days because I understood Sean was on vacation. I was hopeful we could try to reach some agreements. We just didn't have the opportunity. But it was brought to my attention that the plaintiff purchased a Cadillac DeVille in the interim. And then I also addressed the issue with the HELOC funds. I believe the HELOC funds are all gone. And it's my understanding he's also purchasing a property up in Alto for his construction business. So we do need some resources. We're going to have to do appraisals, and we're going to have to get an appraisal of the business and his construction property. I don't think the amounts that I requested are ridiculous under the current circumstances. I did provide detailed budgets with the plaintiff's income and the defendant's income and the respective expenses that they've been paying. So I do think that the $1,500 requests in spousal support and child support can be paid. Further, I did point out in my motion that the plaintiff had a depreciation expense of $17,000 on the 2025 taxes. So that's money that's on the table that definitely can go towards the defendant to give her some assistance. I understand she's underemployed. She understands that too. She works as a part-time clerk at Napa Valley, close to the girls' schools, and she's been tasked with running them and getting them to their activities and things to that nature. She's looking for full-time employment, so that continues to happen at this point in time. I think we both agree that this should be referred to front of the court, and then I'm asking that the plaintiff pay the fee if the court's so inclined. And I think that's it. I tried to be as thorough as I could with the data. The plaintiff in his response states that It's nebulous. We don't have all the information, but he has the information. He knows what's in his construction account. He knows what's in the joint bank account. And he even cited on his verified statement, which he signed, what his gross weekly income. And he knows what my client's making because he indicated what her weekly income was. So he has control of all that information. So to say that I don't know, this is premature,
And now the case takes a serious turn. We're no longer just talking about money, we're hearing allegations of verbal abuse, financial control, even unwanted contact. In family court, these claims can heavily influence custody and support to credibility, safety, and trust.
There's nothing grounded to support my numbers. I provided the information that we had to the court with very detailed budgets based on the bank statements from Lake Michigan Credit Union. And then I think my client should take over a car payment of $548.74. The plaintiff has been making that for her. So, but she's been making her own cell phone payment. And he hasn't provided or offered any type of financial assistance to her since she vacated in January. And we do cite verbal abuse, financial control, and unwanted sexual contact for her removal. And I don't think she should be punished for wanting to remove herself from that type of environment, living with her grandmother and trying to keep the peace, and then blamed. And I think the court did see the text message that the plaintiff did send her, which I did attach. And I understand during these situations, people say things that aren't very nice, but it's just indicative of his nature and how he's been treating her and discounting her worth and things to that nature. So we are requesting some assistance here temporarily. I'm hopeful that we can get into mediation once there's exchange of discovery. And then if it's plaintiff's contention he doesn't have any money, I'm not sure how he's making the house payment and the HELOC payment. And the HELOC, that $76,000 went into his business. So he's paying that, but that was to maintain his business. So I respectfully request the $1,500 in spousal support and $1,500 in temporary child support. And we refer this to friend of the court. And if the court wants to make any adjustments on those numbers, I'm open to preserving the equities of the parties and adding that back in from the house equity, or however the court thinks that's fair.
Well, thank you. Mr. Cox.
Thank you, Your Honor. I think that there's some good news here, and I think that the parties agree, unless I misunderstood, that a temporary order would see them both having joint legal custody and joint physical custody. Your Honor, my client is not opposed to an order that says they have equal parenting time, but I think it's important to keep in mind when we later touch on the financial issues here that my client is the only caretaker of the eldest child. Although, again, he'll agree to an order that says he has equal parenting time, he doesn't. At this point, mother has 3 nights a week, and he has 4 nights a week. And again, I'm going to repeat myself, mother has 3 nights a week with 2 children. To get this motion resolved, we're happy to enter an order that says equal parenting time. And frankly, my client doesn't have any opposition to equal parenting time. So I think the custody and parenting time issues are, I think, cleaned up this morning, okay? The financial picture, yes, Your Honor, my client doesn't have any money left over, and I'm sorry, but I'm going to roll you through the expenses here. So he is now paying the mortgage payment, Your Honor, at $1,000.
Here comes a classic defense move. Lay out every single expense, mortgage, insurance, credit cards. It's designed to show there's nothing left. But here's the catch. Courts don't just look at obligations, they look at priorities. What you choose to pay and how you spend matters just as much.
$521.49 per month. He is paying the HELOC payment at $475.47 a month. So mortgage and HELOC, we're at a little over $2,000, really close to $2,100 a month. He is presently paying his wife's car payment, which we thought was $576. Okay, let's call it $548. No big deal there. The car insurance for that car is $185 per month. He is paying his wife's Chase credit card, only the minimum, at $397 per month. He is paying his wife's Meyer credit card, her personal credit card, for $365 a month, and happy to continue to do that. So between credit cards, car insurance, he's at $1,523 a month. Let's move on to health insurance. Self-employed health insurance is no party. I can attest to that. He is paying $276 a month for the family self-employed health insurance plan. He is paying $67.96 per month for the dental. He is going to pay $1,500 on Tuesday to have his wife's car's brakes fixed. The lie that somehow that this money was dumped into his business is not true. The mother in this case, I'm sorry, I'm going to say it, is a financial disaster. She is not able to handle finances. The evidence will show, and let's hope we don't get to a hearing, that 75,000, yes, my client acknowledged that 9,000 of it did pay credit cards that were attributed to the business, no doubt. But the bulk of that 75,000 was used to pay off the misspending habits of the mother in this case. So if Ms. Jernigan wants to argue that my client isn't doing anything and isn't supporting his wife financially, that is utter nonsense. So if Your Honor wants to say, you know what, let's just scrap that whole thing and let's start, wading through the weeds of child support calculations and spousal support calculations, I would have a request to Your Honor that I think makes a lot of sense. All of these bills and more that I haven't even stated that my client is presently paying for, he will enter into a court order saying he will continue to meet all of these financial obligations. He is paying the kids' sports fees. He just got done paying for driver's training. Mother doesn't want to work. That's her choice, okay? But to walk into your courtroom, Your Honor, and say, oh my goodness, this guy isn't supporting his wife at all. Let's hit him for $1,500 in child support and $1,500 in spousal support. It is nonsense. My client is a good father. He is a good provider. And this sexual nonsense is a bunch of malarkey. The point is, he cares about his kids. He is a hard worker. He's not worth the hundreds of thousands of dollars that they're saying is, but yeah, he's paying all of these bills, Your Honor. He is making sure that his wife is comfortable, and he's making sure that his children are comfortable. And to say that he should pay something beyond that, I think is absurd. And again, I'll repeat, we will enter into a status quo order that has him maintaining all these bills. Thank you, Your Honor.
All right, Ms. Jernigan?
Your Honor, I did pull his Rosalind construction account. There was a total deposit in February of $33,000, and then he just told my client that he pulled in $36,000. It's my understanding the credit card debt has not been racked up by my client, but by the plaintiff, and she has been precluded from accessing the joint account or use of the credit cards. So we do need some money here. She has to pay me. We're going to need some appraisals. So there has to be some sort of benefit or money going to my client on a monthly basis during the pendency of this case so we can move forward in her defense and to, figure out the values of the plaintiff's business and the value of the house and the value of the property in Alto. It doesn't make sense that he went out and bought that Cadillac when he had 2 Dodge Ram trucks to his disposable, the motorcycles, the boats, and things like that. So we would maintain the spending is coming from his side of the ledger.
Your Mayor Sprawn briefly, he bought a $3,200 Cadillac. Woohoo! So you see how they tried to make that even sound nefarious, like he had done something stupid, like gone to a Cadillac lot and bought a $57,000 Cadillac. He bought himself a $3,200 vehicle. There is not some sort of devious financial intent here. And this goes back to our original theme and our response, Your Honor. We're getting ahead of ourselves. I mean, we need to have discovery, and all these grandiose, appearances of fraud they're trying to make on him will be easily fleshed out in discovery. This 75 equity loan was brought on by mother's excessive spending. It wasn't an issue today. It's always been an issue. And frankly, I think that the bills I rattled off to Your Honor demonstrates that my client is a responsible parent and a responsible spouse. Thank you, Your Honor.
Your Honor, just
Yes.
one thing. I don't think the plaintiff could deny that he quit Montreal Construction and violated their non-compete, and there was $15,000 to $30,000 that had to go to be paid on that issue alone. So I don't know if Sean would like to speak to that.
Yeah, that sounds like an issue, a property dispute issue that I can't get into the weeds of this morning, Your Honor. But I think Ms. Jernigan doesn't want to say, Your Honor, oh gosh, I didn't realize that Mr. Cox's client was paying all those bills. If she wants to pay all these other bills herself, she can have at it, and we'll calculate a number that might be fair to her. But My client is willing, Your Honor, to pay what is in excess of what they are seeking, ironically, in a status quo order.
Well, and I did put what he's paying in his budget attached to our motion, very detailed.
There's no money left over, Your Honor. It doesn't exist. So if they want to blow up the status quo, then we're probably going to have to come back in 2 weeks with budgets to figure out what a real number looks like.
Well, and I will note, I was looking at the exhibits, Mr. Jernigan, that you attached, and I know you don't have anything for life or health or auto listed that he's paying, and it sounded like he is paying some of that. Is that correct, Mr. Cox?
That is correct, Your Honor.
So I think there's some real issues with the budgets at the moment.
Your Honor, I do have on his plaintiff's income and his monthly living expenses. I have health insurance at $276.46.
And the judge plays it safe status quo. No big changes, no winners yet. Translation: I don't have enough clear financial truth to act. This is the calm before the storm, because once full discovery comes in, the numbers will tell a much louder story.
Sorry, I have a cold. And auto insurance of $186.33. So that was included on his budget. And then the car payment to my client's side of the ledger, because I think she should take responsibility for that. And it's a very nominal budget. And then she would take over the tutoring expenses. So his monthly living expenses are $5,160.45. With the income of $8,333, then there's a difference of about $3,000 to his benefit. And then my client's expenses, her gap is $3,000. So
Your Honor, we're trying to have an evidentiary hearing on a Friday. This is not the right way to do this, and there is no money left over. So if you want to pick a support number out of thin air, we're going to have the whole financial arrangement blown up. If Ms. Jernigan wants to do something different, I would strongly suggest that we have a little more accuracy on the fallacy that's being presented to the court about how much income we have, and maybe come back and see Your Honor a couple of weeks if that's what they want to do. Again, I'll repeat, my client is willing to pay the status quo. He does not have additional dollars to give her. They don't exist.
All right. Well, I will order that there be a status quo order entered regarding the finances. I'm not going to start changing anything at the moment. It sounds like there's an agreement regarding joint legal and joint physical custody. And with that agreement, is there any need to send this to the front of the court?
Well, I think for maybe child support.
Child support? Yeah, we can do that.
Okay.
Your Honor, the plaintiff's discovery request, I did send a subpoena, was due, I think it was Tuesday to me. So that's outstanding. I would like to reserve the issue of spousal support, because we're going to need funds to be able to do appraisals and things to that nature.
Yes, I mean that's always, you don't necessarily need to reserve it. It's a temporary order. You can come back and ask for an amendment.
Okay.
No problem. And Mr. Cox, when can she expect the discovery answers?
It was sent yesterday, Your Honor.
Oh, okay. I thought it was due. Oh, you sent it yesterday.
I didn't know I was going to do a motion to compel, Your Honor. I'm sorry. We're doing the best we can here.
Okay, no, it's fine. I'm just trying to save that sort of thing.
Certainly.
So they have been answered.
That won't be necessary. It will be provided.
All right. Is there anything else I can address?
Nothing further. Thank you, Your Honor.
The breaks, Your Honor. So I wanted to make sure that the breaks were going to get paid for.
I believe Mr. Cox said that he was going to pay for, what was it, $1,500 for car repairs?
That is what I said, Your Honor. You're correct.
I just want to make sure. I would like to put that as part of the order.
He's going to pay it. You put it in the order. That's fine.
Okay.
All right.
Anything else?
Thank you, Your Honor.
So now it's your call. Who do you believe? Is this a case of hidden income or just overwhelming expenses? Because when the next hearing hits, one thing's certain: the financial truth won't stay buried for long.